Ever wanted to bounce around an HR issue with a knowledgeable lawyer? Well, now you can. Welcome to We Have This Employee, workplace scenarios from CIE Legal's HR lawyers, where Andrew Marr and Ines chat about their perspective on an HR hot topic.
Welcome to another edition of We Have an Employee. Now today we're going to be talking about flexible work arrangement requests. So we have an employee who is a manager in a mid-sized marketing agency. She's been working full-time for 2 years and has been working 5 days a week from the office. She returned from parental leave 6 months ago and she is the primary carer of her 12-month-old daughter. She's put in a request to the employer in writing to work 3 days per week from home, and that's Monday, Wednesday and Friday. Now, the reason she's given for the request is the office is quite far from her home, so working from home means she can drop off later and pick up earlier, and her partner works away Monday to Friday and is only home on the weekends. So she's the sole person dropping off and picking up her child from childcare. So that's let's unpack that. What's her role as manager entail? Okay, so she manages about 10 staff. And those staff comprise sales and customer service, marketing assistants and graphic designers. So it's a fairly broad range.
Yeah, that is broad.
And since her return, this is just a bit of background as well, there have been performance issues within the team and deadlines have been missed. There's been high absenteeism, some missed opportunities because of callbacks not happening or work not getting done on time. So the GM, who the employee reports to, has had to speak to the employee about these issues recently as they relate to her team. What does the employer need to do?
Okay, so it's good context. So first of all, if an employer gets a written request for flexible working arrangements and the employee believes that they're eligible, then that's the first thing you need to look at is, does the employee actually have a right to do this under the Fair Work Act?
And does the employee have to say, I am putting in a request for flexible work arrangements under section, say, 65 of the Fair Work Act, or is it enough just to put it in writing?
No, there is no requirement. The fact that it's being put in writing is enough to trigger it if they have the eligibility.
Yeah, right.
So the criteria under the Act, there's about 5 or 6 of them, but eligible employees, first of all, must be employed for 12 months.
Okay. Yep.
So continuously. That's for permanent staff. And for casual employees, if they have been regular and systematic, so they're regular casuals, and there's still a reasonable expectation of ongoing work, then they actually also have the right to put in a request.
Yeah. Now, look, that's the old challenge. Who is a regular and systematic casual? Based on the decisions of the Fair Work Commission in a slightly different context in terms of unfair dismissal. Regular doesn't have to be that regular, but you have to work more than once. And systematic really only relates to there being a system of casual engagement. So it's not the old thing that you see in the movies where everyone in the 1920s turns up to the gate of a lumber yard and they say, you, and you, 1 day's work. There has to be sort of, a rostering system. You have to be on the book. So that's, when it talks about systematic, that's the way that the Commissioners interpreted those legislative provisions and that sort of language that's been used in the Fair Work Act and its predecessor acts, the Workplace Relations Act and so on. So people get a bit hung up on this whole regular and systematic and say, oh, well, I don't really need to do it because they didn't work, they only worked 3 hours this week and they are not working next week and they're working 8 hours a week after. At the end of the day, provided you've sort of got the period of employment satisfied, that's going to be enough. Yeah,
and I think that the fact that casual employees can make this request also throws people sometimes. But
yes.
Yeah, like you've said, it doesn't have to be very regular or systematic for it to fall under regular and systematic.
Because we all would have thought that casual employment is a flexible work arrangement by its very nature.
Exactly right. So that's the first thing that you look at. How long have they been employed for? Are they casuals? It doesn't mean that it's a no, they're not entitled to it. You just need to look at what the history is there. And then, do they fall into the circumstances that's allowed for under the Act? And that's written word for word, so that's good. At least it's a little bit clear for employers.
And what are they?
So it includes employees that are pregnant, employees who have parental responsibilities or
so
care.
In our case, the employee's put in the request satisfies that particular requirement.
So she does. And that also includes those who care for children who are of school age as well.
As opposed to those who don't care about children.
So parents or carers, hopefully all of them care for the children. The employee is a carer, so that might be that they're a carer for a person with a disability or an older parent. The employee has a disability. Employee is 55 years of age or older. And one of the updates that happened a couple of years ago is the addition of those employees that are experiencing family and domestic violence or are caring for those who are providing care or support to people who are experiencing family and domestic violence can also put in a request.
Yeah. So you could actually tick more than one box. I mean, quite clearly, each one of these is not necessarily mutually exclusive from the others, but provided you satisfy one of those requirements, then you're going to have a right to put in a flexible work request and have that request dealt with in a particular sort of way, which no doubt you're about to talk about.
Exactly. So the employer has received this employee's request and they have 21 days to respond under the Act.
In writing.
In writing.
In writing, yeah.
And it's worthwhile saying that since the changes that happened a couple of years ago, so I think it was June 2023 when these changes came into force in the Fair Work Act, beforehand there was, still a right to request flexible working arrangements and there was still an obligation to respond within 21 days, all in writing. But since the changes, things have become a lot more onerous. There's a lot more there. And as we mentioned previously, the Commission now has powers to conciliate and arbitrate.
Yeah, so it was a little bit of a toothless tiger before. It was pretty easy to rely on one of the grounds that, again, I don't want to jump jump ahead of what you're about to talk about, but could rely on one of the grounds that was a recognised ground for saying no. And to some degree, that was kind of the end of it. I mean, they had a protection in terms of the fact they'd exercised a workplace right, so you couldn't take any punitive action against them because it would be unlawful, the breach of the general protections provisions. But in itself, once you'd said no, these things kind of fizzled out a bit. I mean, you ended up with an unhappy employee. But now it doesn't fizzle out. So what are the sort of things that would happen? You've received, in this case, the employer's received a flexible work request, requesting a work from home 3 days a week. What do they do next? What's the next thing they need to do in dealing with this request?
Yep. So again, the Act is pretty prescriptive here in terms of telling employers what they need to look at. And there have been cases where employers have fallen down in these procedural parts and as a result have resulted in orders being made by the Fair Work Commission for certain flexible working arrangements to be put into place. So when you get a request, before you refuse it, and that's the way the wording of the legislation is as well. So it's the employer may refuse the request only if, and then there's like ... So it's line by line. When you're an employer, you should be looking at this and making sure that you're ticking every box.
Yeah, so it's not just the reason for refusal that the Act deals with. There's actually a set of procedural requirements that you need to meet before you can even refuse. I mean, I'm not saying that everyone's going to refuse a request, but there will be circumstances where the request is not going to be that palatable necessarily to the employer and they will be thinking about potentially saying no. But these stages they need to go through. So what's the first one that you'd need to do?
Yep. So first of all, you need to discuss the request with your employee. So it's not enough just to consider it behind the scenes and write a letter saying thanks, but no thanks.
But no.
Yeah. You actually now need to discuss it with the employee. And it's not just about discussing it, it's also about, and I'm reading here from the Act, genuinely trying to reach an agreement with the employee about accommodating their working arrangement request or finding workarounds. So it's not just about discussing the request with the employee, but it's actually also genuinely trying to reach an agreement. If it's a no to what they've suggested, as the employer, you actually have to put up some circumstances or situations that might work for you.
So no, in a sense, is not really an option. Just an outright no, that does not work for us, is not going to get you anywhere as an employer in terms of satisfying the requirements of the Act. You've actually really got to go back and, while it may not be agreeing to what the person requests, you've really got to compromise a bit, at least in the early stages of addressing this request, by putting some sort of counter proposal to them even if that counter proposal is pretty close to the status quo. Would that be a fair assumption?
Yes, that's right. And it's on the employer to be proactive in thinking of other circumstances or other arrangements which the employee hasn't put forward.
Yeah, okay. Yeah, so it might address the concerns that the employee or the reasons the employee has raised in support of their request, but it actually might be quite a different proposal to what they're requesting.
Yes. And in addition to that, now this is an interesting one, the employer has had regard to the consequences of the refusal for the employee.
Not for the consequences of the refusal for the employer, which under this new system could be a little bit dire, but they actually have to look at what it means for the employee. So you really are looking really beyond just the statement of what the employee has put in support, even if they may not have actually put any reasons in support. They might have just put the request in and said, I've got caring obligations, this is what I want. So you really do actually have to look behind that and work out in the employee's particular circumstances, some of which may not be known to you, of course, as an employer. You've really got to sort of probe into that. Is that right?
Yes, that's right. And of course, the last little point is that the refusal needs to be on reasonable business grounds. So, which has always been there, those reasonable business grounds.
That's been something that's been there as long as these right to requests have been there. And while there is case law that deals with what's reasonable business grounds, I think I can't remember. Are they still defined in that section? Because they used to be,
yes,
or at least have some examples. But what's reasonable to one, as we all know, may not be quite so reasonable to another. So, what sort of grounds can you rely on?
So with it, and yes, you're right. It's suggestions. It's not an exhaustive list. So it's just some examples. But for example, that the new working arrangement requests would be too costly for the employer. That there's no capacity to change the working arrangements of other employees to accommodate the request. That it's not practical to change the working arrangements of other employees.
Yeah, I wonder what practical means in that situation. I gather that would mean that, shifts would have to change and other people who might have their own lives sort of set up around their shift patterns. The idea of having to let someone work, say, all morning shifts, for example, when you've got a rotating shift pattern, obviously that's going to have a knock-on effect to other people. So that might be one of the things that you can rely on and say, if they all only worked mornings instead of their normal rotating, morning, afternoon and evening, then other people would actually have to miss out on working the morning shift, and that would be unfair because it's going to be disruptive to them, to their current plans. So I guess that makes sense, doesn't it? Yeah,
that does make sense. And of course, if it's impractical to recruit new employees as well to accommodate the working arrangement request, so that's another kind of, it falls into the costly side of things, right?
Right, but it does anticipate that you may have to you may not have to, but the Act seems to anticipate that it's reasonable to assume that an employer might actually have to hire some more staff to deal with this request, even though it does say that, in certain circumstances that might be unreasonable, that requirement. It's obviously considered that it might be reasonable in certain situations. So you actually have to go out there to market and get someone to pick up the slack effectively.
What comes to mind is job share arrangements. Yeah. So if you have someone in a full-time role and they ask to go part-time, then what the employer could look at is to get another part-timer, and then they essentially start job sharing what would have been a full-time role originally.
Yeah, which actually leads to another question. These flexible work arrangement requests are often in relation to a particular set of circumstances that existed at a particular time in an employee's life.
Yes.
They may well change, and I'll let you talk about that in terms of the degree of permanency that these requests entail. But just thinking about that, the job sharing issue, it does become problematic, doesn't it? Because if you've got a temporary flexible work arrangement while a parent has their children at home before they start, say, primary school, or even before they go into certain childcare arrangements, you are a little bit hamstrung in terms of doing a job share, because at the end of that period where the employee would, I assume, have the right to go back to you and say, oh, well, I'd like to go back to my normal arrangements now because that particular set of circumstances has stopped being the case. Well, you're stuck with this other person who you might have to make redundant. So, I mean, there are very significant implications in terms of the amount of time that an arrangement has to stay in place and the sort of compensatory measures that you take as an employer to make sure the business keeps running smoothly. So, it can be a little bit tricky because you don't want to end up having to bring someone on just to make them redundant. You also have, I guess, the other challenge just thinking through this is that if someone said to you, look, I want requesting flexible work arrangements, you go through the process, they say, oh, look, I think it's going to be about 6 months. You agree to that. Okay, that's fine. We'll agree to it for 6 months. And you hire another person to come in and say job share, for example, for the 6 month period, put them on a maximum term, sort of fixed term contract. Then you get to the 5th month and the person says, look, I haven't got the arrangements in place that I wanted. I'm going to need another flexible work request processed that will deal with it for another 6 months. You can sort of see that for employers, look, it's great for employees, and we all recognise that a modern workplace really does require these sort of flexibilities to assist employees who have got sort of out of work responsibilities that are potentially a little bit of conflict with their existing work patterns and what have you. But for employers, like every benefit for an employee that is protected or provided by legislation, there can be a downside for employers. And you can sort of see in situations that while the employer might want to do the right thing and might want to assist the employee, some of the logistical issues can be
definitely. Even just going further with that job share example, it's very easy to say, oh, yeah, they'll just recruit another person. But recruitment takes time and money. It can take several months to find someone. And then, I think on average it's like 12 months or 18 months of after employment that an employee kind of starts contributing positively to the workforce.
It's skilled up really to the level that the person whose hours they're replacing, that they're actually almost up to that level at the same time. I mean, at certain jobs, it may not be like that, but you can imagine that certain other jobs, even for example, if we're talking about our manager in this situation, if she wanted to go and do, it's not what she's asking in this scenario, but if she did want to work, say, part-time, it may be quite difficult to get someone to come in and pick up those managerial responsibilities, because they are going to require a very particular skill set, but also knowledge of the organisation and its processes and just the way that it operates. And you're right. It could take 6 months, almost the duration of perhaps what a flexible work arrangement might be in place for. So it is challenging for employers sometimes to navigate these, even if they really do want to assist the employee because they're a valuable employee, they're hardworking, they're contributing to the organisation, and the employer wants to recognise that and really does genuinely want to help them independently of their legal rights and obligations. You can see that logistically sometimes these things can be pretty difficult to navigate.
Very much so, and especially for those smaller businesses too.
Yeah, of course, depending on the size of your organisation, it may be easy to sort of move the chess pieces around a little bit, but if you've only got 3 chess pieces, not so much moving you can do.
Thanks for joining us on We Have This Employee. If you like what you've heard, please subscribe, leave a review, and share this episode with your colleagues. You can find this podcast and all episodes in the series on our website, www.cielegal.com.au, on LinkedIn, and all the usual podcast hosting platforms.